Defendant poses no threat to the public. Defendant is not a flight risk. Defendant's lack of criminal history, age, medical concerns, family support, attorney-client relationship, and condition that she will be placed.
Defendant poses no threat to the public. Defendant is not a flight risk. That is the central plea typed into a motion filed last week in a Vinton County, Ohio courtroom. The defendant is a 66-year-old grandmother, and she wants to go home. Now hold that sentence in your mind, because here is the visual that defines everything that follows. Imagine a single-family house where the floor is not a floor. It is a carpet of garbage, animal waste, and rotting food so thick that sheriff's deputies had to wrap their boots before stepping inside. An odor so violent it struck investigators at the curb. That was the home on Omar Street. A grandmother lived there, so did 16 children. The grandmother now asks the court for freedom. Her lawyer says she merely resided.
Christina Ciders is a grandmother and a mother. She's a wife, and she wants out of jail. Christina Ciders is accused of abusing 16 of her grandchildren by allowing them to live in conditions in a home in Vinton County, Ohio, that the sheriff said weren't fit for livestock. The children who were removed from the home, according to the prosecutor, suffered serious physical harm. The nature of the physical and emotional issues the children are dealing with remains under wraps, but we know all 16, including an 18-year-old, are in therapeutic foster care. Therapeutic foster care, it's different from traditional foster care. The caregivers are specially trained to help children who may have emotional or behavioral issues. The county had to find families to take in all 16 children. Let that sink in. Christina faces...
Before we go deeper into what the documents actually show, make sure you are subscribed to Endless Cryme, because we don't just cover the story, we follow the evidence. The legal filing is a motion to modify bail. It is submitted by Christina Ciders' public defender. Christina Ciders is the grandmother charged with 16 felony counts of child endangering, one for each grandchild removed from that house on June 30, 2026. Alongside her sitter husband Gary Ciders Sr., her son Gary Jr., and his wife Elizabeth. All 4 adults lived under that roof. All 4 now wear identical orange jumpsuits in the Southeast Ohio Regional Jail. Their bonds are set at $300,000 each. None of them can pay even a fraction of that.
Those child endangering charges, and so does her husband Gary Ciders Sr. Their son Gary Jr. and his wife Elizabeth Ciders, they face the same charges for their 16 children. All 4 have pleaded not guilty to these charges. Now they are just waiting to see when the case will be presented to a grand jury and what happens when the grand jury returns indictments. And it's possible the grand jury doesn't indict members of the Ciders family. That's a possibility, but that seems very, very unlikely. And as 3 of the Ciders family members remain in custody in Southeast Ohio, 2 of them want to be released from jail. Elizabeth Ciders' attorney has asked that her bail be modified, saying she can't post any bail and wants to be reunited with her children. And now Christina Ciders, the grandmother of the children, is also asking Judge Rogers to modify the terms of her bail. Christina, Gary Jr., and Elizabeth are being held on a $300,000 bond. Not one of them can post that much cash, not even close. That's painfully clear in this case. And if they did post bail, they would have to wear a GPS monitoring bracelet. And now Christina Ciders' lawyer is asked.
The grandmother's motion is a quiet, surgical document. It quotes the Ohio Revised Code. It cites the state constitution. It argues that bail is not punishment.
Bail is, of course, supposed to ensure that a person charged with a crime shows up for court. It's not supposed to be a punishment. Roberts cited case law, writing, if a court orders financial conditions of release, those financial conditions shall be related to public safety, the defendant's risk of non-appearance in court, the seriousness of the offense, and the previous criminal record of the defendant. Roberts continued, the court must consider the defendant's ability to pay. Setting a high bail in order to keep someone accused of a crime incarcerated pretrial is both statutorily and constitutionally unlawful.
That a 66-year-old woman with no criminal record and lifelong roots in Appalachia is not a flight risk. It says she has family support. It says she will wear a GPS monitor. It asks for a mental health evaluation because she may not understand the charges against her. And woven between every line is a single legal thread. Christina Ciders did not harm these children. She just lived in the house. Exhibit 1, the motion's own words. To date, the state has presented evidence only that the defendant resided and was present in the home on June 30, 2026, and that the conditions of the home were unsanitary to the extent that the removal of the children from the custody of their parents was deemed necessary by authorities. Stop right there. The grandmother's lawyer concedes unsanitary conditions. That is in the filing. Not a denial, an acknowledgement. The document then pivots hard. The weight of the evidence against defendant is minimal. In fact, to date, there is no evidence that has been provided which would support the finding that defendant committed any acts of abuse, let alone that any of the children suffered serious physical harm because of abuse by defendant. The defense is not that the house was clean. The defense is that grandma was a bystander in her own home. She merely resided.
Christina Ciders' lawyer also questions the weight of the evidence against her. The state has charged defendant with endangering children, which would require evidence that on or about June 30th, 2026, defendant did abuse each of her 16 grandchildren and that she caused serious physical harm to every one of the children. To date, the defense has received scant evidence suggesting defendant committed any of the alleged offenses. The weight of the evidence against defendant is minimal. In fact, to date, there is no evidence that has been provided which would support the finding that defendant committed any acts of abuse, let alone that any of the children suffered serious physical harm because of abuse by defendant. To date, the state has presented evidence only that defendant resided and was present in the home on June 30th, 2026, and that the conditions of the home were unsanitary to the extent that the removal of the children from the custody of their parents was deemed necessary.
That phrase is the fault line of this entire case, because on the other side of that fault line sits the Vinton County Sheriff. He told reporters the conditions inside the Omar Street property were not fit for livestock. The county prosecutor went further, informing county commissioners that all 16 children, ranging in age from an infant to an 18-year-old, suffered serious physical harm. Every single child is now in therapeutic foster care. That is not ordinary foster care. That is specialized care for children with severe emotional or behavioral trauma. The county had to scramble to find 16 therapeutic beds. Let that number settle. And then ask yourself, if a grandmother merely resided, how does a house become a place that creates 16 therapeutic cases? Here the narrative splits into two parallel tracks. Track one is the legal performance happening inside the courtroom. The grandmother's attorney argues that her client was outside the home when deputies arrived, that she cooperated, that she gave a statement without counsel present for hours at the sheriff's office.
Interesting. Well, it's going to be interesting to see where this goes and where the judge allows it to go, because there's still the fact that these people shared addresses in Gallia County. So they were living together at a house on Honeysuckle in Gallia County when the truancy action was filed. So these people have been living together for a really long time.
Right, and you would think also with regard to that issue that a grandparent would understand that it's in the child's interest and required by law that they attend school when they reach a certain age. And most of the children, or at least more than half of them, are over that mandatory minimum age. And as we talked about last week, they in fact had truancy charges filed on them that never went forward because they couldn't get service. So either they left that place and didn't leave a forwarding location in Gallia County, or the sheriff's office or children's services down there, or the truancy officer. Each school district by statute has the ability and does appoint what they call.
The motion reveals that law enforcement originally came to the house to serve an unrelated misdemeanor arrest warrant on Gary Jr., but they were also executing a sealed search warrant for evidence of a crime the state still has not publicly named. The entire affidavit of probable causes lockdown, challenged all the way to the Ohio Supreme Court. So the grandmother sits in jail, charged with 16 second-degree felonies based on evidence neither she nor the public can yet see. Track 2 is the family history. Before Omar Street, the Ciders clan lived together in Gallia County on a road called Honeysuckle. Truancy charges were filed there. Multiple school-aged children simply stopped showing up. A truancy officer was assigned. The charges stalled because the family vanished. No forwarding address, no paper trail. They resurfaced in Vinton County, same group of adults, same growing number of children, same closed doors. 2 counties, 2 sets of official records, 1 pattern. The grandmother was present for all of it. She merely resided.
Asking that she be released from jail, and her attorney wants a mental health evaluation for her client. Attorney Kanda Roberts wrote, on June 30th, 2026, law enforcement arrived at defendant's home with the purpose of serving another member of defendant's household with an arrest warrant for unrelated misdemeanor charges. Nonetheless, defendant was detained and arrested outside her home. After providing a statement and cooperating with law enforcement during an interrogation at the Vinton County Sheriff's Office without counsel present, defendant was ultimately charged by complaint with 1 charge of endangering children, a second-degree felony for each of her 16 grandchildren who had been residing with their parents in defendant's rented home. Defendant has remained incarcerated since her arrest.
Then comes the ticking clock moment. The motion asks for competency evaluations, not just for Christina, but for Gary Jr. and Gary Sr. as well. That means 3 of the 4 defendants are now floating the possibility that they are mentally unfit to stand trial.
Keep in mind, each defendant has waived his or her right to a preliminary hearing, which would have required prosecutors to present evidence to show there was probable cause that each of them had committed a crime. The case hasn't even gone to a grand jury that we know of. Now, Christina Ciders' lawyer, she's not just asking for her client to be released on bail. She also wants her competency to stand trial evaluated. Attorneys for Gary Jr. and Gary Sr. have also made that request. Roberts wrote, defendant, by and through counsel and pursuant to a revised code, hereby raises the issue of her competence to stand trial. Counsel has reason to believe that defendant is unable to fully comprehend the proceedings in this court and is unable to assist counsel in the preparation and defense of this case. Defendant moves this court to order that defendant undergo a competency evaluation.
If a judge agrees, the case freezes.
Start with the competency request. This is now the 3rd defendant of the 4 in this case who is raising the issue of competency. Are you surprised by that?
No, not at all. I think just by the nature of the offense itself, what's publicly been disclosed, you have to even ask yourself, what are these people doing? What are they thinking? How did this happen? 16 children, or actually 18 children born over a period of 15 years, some of them twins, but wondering what's going on there. And so, as many people will ask themselves, is there something wrong with them? And so I think that itself causes you to think that maybe there should be a preliminary psychological exam of the defendants.
So we have Grandma now. Her attorney, Kanda Roberts, is with the Ohio Public Defender's Office. So they're going to do everything they can to help their client, of course, as any defense attorney would. What's the next step here? I mean, the judge, I'm assuming, Judge Rogers, is going to say, yeah, let's go. Let's do it. Let's order the competency evaluation. So what do you see happening as Grandma's competency is evaluated?
I think you're correct that the trial judge will order the competency exam. Sometimes the defense attorney offers more to the judge as a basis to order the competency exam, such as when I visited the offender in the jail. They couldn't tell me about the offense, or they talked about other things, or they couldn't remember things. Kind of the questions that the psychologist is by statute required to look into. But in this case, it was a bare-boned motion that merely said, I have questions whether or not the defendant's competent. Therefore, I'd like to ask for an exam. Despite the lack of reasons being offered, I think the trial judge will order the competency exam, perhaps just based on the offense itself, the age of the offender, and the request by
the defendants are transferred to a state psychiatric facility for restoration treatment, a process that can take months or years.
The defense attorney, because they're obviously, she may have interviewed the defendant for hours in the jail and reached that conclusion herself, but she just doesn't want to talk about it in her motion. So I think it will inquire into those 2 basic questions. Do they understand the nature and quality of the charges against them, which shouldn't be hard, I think, to understand. You're charged with endangering children, causing their harm, and by neglect, essentially. And then the second point that is always necessary is, can they assist their lawyer in providing a defense? And that's more often the basis for someone being found incompetent.
Let's say, let's just do a hypothetical here, that the reviewer and the court find that she is incompetent to stand trial. That doesn't mean that competency can't be restored. We've seen that in a number of cases over the years where somebody is deemed incompetent, then they are sent to some type of institution and they work on them by whatever means that is, to get them to a level where they can assist in their own defense.
I think that's exactly correct. What will happen is, if they order the exam, she'll probably be examined in the county jail, unless this second motion they filed about a reduction in bond that they can post is granted. but she'll be examined in the county jail, interviewed by a psychologist appointed by the court. They will ask her background questions, questions about the offense, questions about her relationship with her lawyer, and usually they administer psychological tests to determine reasoning and understanding, communication. All of those are key things, obviously, if you're charged with a serious crime, being able to talk with your lawyer about. So they give a battery of psychological tests, and that then is part of their report, and then they render the conclusion one way or another. If there would be a finding by the initial examiner that she's incompetent, the state has the opportunity to ask for a second exam. And at least if it would come out contrary to that, the court itself then can appoint a third examiner kind of as a tiebreaker, or can consider the two competing examinations. I recently had a case where the first representing the defendant, or no, in that case, I was representing the victim. Under Ohio law, the victim has a right to their own attorney. And after the first exam, they determined that he was incompetent to stand trial. I asked the prosecutor to seek a second opinion, which they did. And the second opinion reached that they were competent. And the report that that examiner provided caused the first psychologist to change their mind. And there was then a finding that they're competent. So, I used to like to call some of these kind of exams voodoo science, but they're professional opinions by qualified
Sure.
experts. Some of them have different kinds of leanings and biases. But in any event, the first exam is probably the most important, because either side, if they agree with it and it's documented well, it can be accepted and be the basis for the finding of competency or incompetency.
And while that clock ticks, 16 children wait in therapeutic foster care, their future suspended, permanent custody proceedings already announced by the county.
The Vinton County Children's Services, they're going to be seeking permanent custody of these children. The county prosecutor told the county commissioners that just in the last couple of weeks. I mean, that was before, this week. It was like 2 weeks ago. That early on, what does that tell you if they're seeking permanent custody that early on?
Well, they would have to have a hearing before the juvenile probate judge there in Vinton County. They would have to file an abuse, neglect, dependency kind of charge, which is a separate kind of administrative proceeding in front of the juvenile court judge to make that determination whether the children are at risk, that's the allegation, and whether the custody of the children should not be with these parents or grandparents who had such neglectful conduct over a period of time. So it tells you that they think they have a strong case, number one, and it also tells you that they're willing to go forward.
So here is the question that reframes this entire story as a legal thriller. What happens if the very people accused of creating this horror are deemed too fragile to face it, while the children they allegedly harmed are forced to live inside its consequences every single day? The moral core of this case can be reduced to 2 words from the defense motion. She merely resided. Those words are about to be tested against the Ohio Constitution. In 2022, Ohio voters amended that Constitution specifically to allow judges to consider public safety and the risk of harm to victims when setting bail. The grandmother's attorney quotes the old language, the old tests: ability to pay, flight risk, community ties. But the new amendment hangs over the courtroom like a sword. The judge must weigh whether releasing Christina Ciders back to the care of close family members who were inside the same house, places any of those 16 children at further risk.
There are some interesting little nuggets that she dropped, Kanda Roberts dropped in this motion to reduce bail. She's essentially saying, and we can see where their defense is going to be, what their defense is going to be in this case. But she's essentially saying, look, my client was paying the rent at this place. They were staying there. These are their kids. They are her grandchildren. However, it was still her home. So what responsibility do you still have if you have a family members with 16 kids living in your home, and they go in and they find feces and trash all over the floor, and it's disgusting, as the prosecutors and the sheriff's office have said, um, what responsibility do you still have as the grandmother to ensure that these children are living in a safe environment?
Well, at least that question is, I think certainly grandma has that kind of responsibility, but is it a legal responsibility? If you fail to meet it, are you subject to prosecution for endangering children? And at least I think because of the relationship, say she was just a landlord and was letting friends live there for several hundred a month, it might be a different situation. But since she's a grandmother of the children, I think that she would meet that.
The grandmother says she has nowhere else to go. The house on Omar Street is uninhabitable. Her husband and son are in jail. The children are in state custody. The only family support she can name are relatives who have not been publicly identified. The judge will have to ask, where exactly does a grandmother go when her entire household has been designated a crime scene? And still the grand jury has not returned an indictment. We are in the foggy procedural window between arrest and formal charge. The defendants waive their preliminary hearings, a tactic that prevents prosecutors from having to show their evidence in open court just yet. It is a strategic blackout. In that darkness, the only document we have is Christina Ciders' plea for freedom. It is a masterclass in minimizing legal exposure. At no point does the motion claim the children were safe. At no point does it deny the squalor. It merely argues that the squalor is not her crime. She merely resided. The unanswered question that lingers is the one the motion deliberately avoids. In Ohio, child endangering can be proven not just by direct abuse, but by creating a substantial risk of serious physical harm through neglect. The grandmother's own filing admits the children were removed because the home was unsanitary. That removal was deemed necessary by authorities. If the conditions were bad enough to pull 16 children into state custody within hours, the state's argument is already half written. The grandmother's defense is that she paid the rent and nothing more. But she is not a landlord, she is their blood relative. Under Ohio law, that relationship carries a duty. And duty, once established, does not dissolve because you choose to look away.
Asking that she be released from jail, and her attorney wants a mental health evaluation for her client. Attorney Kanda Roberts wrote, on June 30th, 2026, law enforcement arrived at defendant's home with the purpose of serving another member of defendant's household with an arrest warrant for unrelated misdemeanor charges. Nonetheless, defendant was detained and arrested outside her home. After providing a statement and cooperating with law enforcement during an interrogation at the Vinton County Sheriff's Office without counsel present, defendant was ultimately charged by complaint with one charge of endangering children, a second-degree felony for each of her 16 grandchildren who had been residing with their parents in defendant's rented home. Defendant has remained incarcerated since her arrest.
You can read the full motion for bail modification in the Ciders case right now. It is a public document filed in Vinton County. We have linked it below. After you read the sanitized legal language, after you absorb the argument that a grandmother simply lived in a house, answer this single question in the comments. If she merely resided, who exactly was supposed to protect those 16 children from the horror inside their own home? If you demand accountability that goes beyond the headline, like this video, share it, subscribe to Endless Cryme, and turn on notifications. We do not chase the noise, we read the motions.